Hello, my name is Amanda Gamble. I'm a family law associate here at Bursford Booth, and I've been a family law litigator in the state of Washington for nearly 8 years. Today, I would like to offer what I believe are the top 5 tips for navigating the family law mediation process. Mediation is a fundamental tool in family law matters. Personally, I have been involved in nearly 200 mediations. So, from my perspective, the top 5 tips for a smoother mediation process are as follows. One, understand the process. Two, prepare mediation materials. Three, know your limits. Four, be ready to compromise. And five, don't sign unless you agree. So first, what is What is mediation? In order to be successful in mediation, you need to understand both the process and the purpose of mediation. Mediation in a family law case is a confidential, court-ordered process where litigants work with a neutral third party, a mediator, to try and resolve disputes without going to trial. The key is the fact that what is said during mediation cannot be used in court, with some very narrow exceptions like threats of harm. The confidentiality piece is meant to encourage a robust, open, and honest conversation. It allows people to feel comfortable to propose agreements they might otherwise not if the case isn't going to settle. The mediator is a neutral third party. Mediators do not make decisions or offer legal advice. They facilitate discussions, help explore options, and often keep parties on track toward the ultimate goal of settling their case. They can also offer their perspective on the strengths and weaknesses of your case. And I suggest when selecting a mediator for your family law matter, you select someone with family law experience. The mediator's experience can impact both the analysis you would receive and the success of your mediation. In family law disputes, we use what is known as shuttle mediation. This means that the parties and their attorneys, if you are represented, are in separate rooms, and the mediator shuttles back and forth between the rooms. This can occur virtually as parties are kept in separate breakout rooms. If an agreement is reached, it will be reduced to writing in a binding and enforceable agreement. And the terms of that agreement are then reduced to the final orders. This means that the agreement that is reached at mediation is not the end of your case. You need final orders, which are then signed by a judge to officially conclude your case. However, entering into a final agreement at mediation is noteworthy. You have agreed essentially to what will go into your final orders. Now, now that we know what mediation is, my second tip is prepare mediation materials. The content of mediation materials varies from person to person. Typically, a mediation brief comes in the form of a letter to your mediator. The mediator's engagement letter often dictates when the mediation materials are due and if they're requesting any specific documents. Unlike in a court setting, there is technically no consequence for not providing the mediator with materials. However, if you kind of are in a way harming your own case and the chances of a successful mediation if you choose not to provide mediation materials. A mediation letter sets out the background of the parties, the issues to be resolved, and often concludes with a proposal for how you want to resolve the pending issues. It is also helpful to create an asset and debt spreadsheet for cases involving the division of assets and a proposed parenting plan for cases involving children. This guides both the mediator and the other side in understanding your perspective. It might also be helpful to provide the mediator with the initial pleadings, so the petition, response, and key orders from the case, like temporary orders. If your case involves financial issues, a financial declaration, and recent statements to support the content of the financial declaration is helpful. The mediation letter guides the mediation letter guides you in understanding what you are requesting. It can also help shape your goals for mediation. Just as you would not go to trial without providing the court with a trial brief, you should not attend mediation without providing a mediation letter or brief. Mediation materials outline your key points of view and often shed light on where the parties might differ on the final resolution of issues. The work and time it takes to prepare the mediation materials is definitely worth it. Third, know your limits. During the preparation process that we just spoke about, you will have hopefully developed some goals. It is important to know where you're willing to what you're willing to compromise on and what is your non-negotiable category. Now, this might change throughout the preparation process or during mediation itself. That's okay. However, your non-negotiable category is important to know. Mediation generally takes about 6 to 8 hours, depending on the pending issues, although they can go much longer. I think my longest mediation is about 12 hours. So it is important to know where you draw the line. What are you willing to live with, and what are you absolutely not going to back down on? Basically, what is the hill you're willing to die on that will cause you to go to trial? When mediation has dragged on all day, you are near a full resolution, signing an agreement can be enticing. It is important in those moments, in particular, to know your limits, which brings us to number 4 on the list. Be ready to compromise. Mediation is only going to be successful if each side compromises. It is nearly impossible for everyone to walk away from mediation without some compromise. Yes, it is important to know your limits, but it is also important in the context of mediation to be flexible. If your matter involves children, avoid using the mediation process to quote unquote win against the other parent. There is no winning in mediation. There's only cooperation and compromise. That does not mean that you have to cave on all of your issues. It simply means that you need to be able to concede on some issues. This is also where having representation can be helpful, as attorneys can assist in creative solutions to support both parties coming to a compromise. You are unlikely to get everything you want. I tell clients all the time, you are likely to just feel okay about your final agreement. But if you reach a fair and reasonable agreement, it is often far better than a costly and lengthy trial. Which brings us to tip number 5. Do not sign that final agreement at the end of your mediation unless you agree. After you have reached the terms of the agreements and they're reduced to writing, we sign what is called a CR2A. A CR2A, or Civil Rule 2A agreement, is a binding enforceable agreement. It outlines the terms of the settlement reached, and changes to the CR2A are nearly impossible. There are very few exceptions, which I'm not going to go over today, but I always tell clients, when you sign that CR2A, that is it. There are no changes. You do not get to call me the next day and tell me that you don't like the agreement. You're signing it voluntarily, and you understand that it is binding and enforceable. Generally speaking, a CR2A is just not modifiable after it is signed. Mediation is often an emotionally charged day. Recognize and understand that going into mediation. It will save you the energy the day of. It will also prepare you to sign this final agreement, especially if you're resolving all issues of a dissolution matter, and that includes children. It is going to be an emotional day. So, do not sign an agreement. You do not agree if you do not agree to the terms of the agreement. You do not have to love the terms of the agreement. You do not have to like the terms of the agreement. However, you will be bound by those terms once you sign. And while the terms of the final agreement may not be your favorite, you did work hard with the other side to compromise and craft the agreement. So, if you attempt not to follow it, the other side can file a motion to enforce the CR2A. This is why it is important to note that the day is going to be emotionally charged. You are also going to want to sign a CR2A. You worked hard all day. However, you don't get to make changes later. You also don't get to say, actually, I don't want to follow this. I want to go to trial. Now, there are often provisions in CR2As that address drafting issues that may arise. So drafting issues are different. The substance of the CR2A does not get to change. And I'm going to repeat it. Know that a CR2A is binding and enforceable even before final orders are entered. To recap, my top 5 tips for a smoother mediation process. 1, understand the process, know what mediation is. 2, prepare mediation materials. 3, go into mediation knowing your limits. 4, know your limits, but also be ready to compromise. And 5, don't sign a CR2A unless you agree to the terms. Thank you for being here with me today. If you have any questions or want assistance from one of our wonderful family law attorneys here at Bursford Booth, please give us a call and we'd be happy to assist. Thank you so much.